It will be heard by the Supreme Court on Wednesday. We want to welcome you all. Thank you for joining us here today. We're really excited to have some fantastic panelists here with us today, as well as FAIR's Executive Director, Monica Harris. So I want to welcome all of you who are joining us to hear about this very important case and all of the potential implications that could come from it. My name is Leanne O'Neill. I'm the Director of Legal Advocacy at FAIR and have the pleasure of hosting you all this afternoon. I quickly want to go through and introduce our panelists before we get started. And then we'll give a little bit of a background about the case that we're talking about today. And then we'll hear from each of our panelists about their background and how they're involved with this case, their legal arguments that they've put forward to the court. And then we'll have an opportunity for questions and answers also later. First, I want to introduce Mitra Farauher. Oh my gosh, I think I just said it wrong again, even after I practiced. Mitra, please correct me.
It's okay.
Mitra is, she practices U.S. constitutional and civil rights law and international human rights law as well. She actually represents several detransitioners in federal courts, alleging that violations of their civil and constitutional rights have occurred. Contributed to the development of the UN human rights norms for corporations with a special focus on ethical and legal complicity. She has served as an advisor to the Ethics Committee of the Board of Directors of a global Fortune 100 company on matters related to international public policy and human rights and integration of human rights and operations in challenging environments. Prior to that, Mitra has worked for an international law firm and advised on a wide range of cutting-edge legal matters involving harmonization of different legal systems, cross-border litigation, international structured finance, and tax structuring of cross-border mergers and acquisitions. Mitra has lived, studied, and worked on both sides of the Atlantic, which has enriched her personally and professionally. In addition to her JD, Mitra also holds an LLM from Boston University School of Law and an LLM in International Human Rights Law from the University of Geneva in Switzerland. Thank you for being here, Mitra. Next, I want to introduce Ilya Shapiro. Ilya is the Director of Constitutional Studies at the Manhattan Institute. He was previously the Executive Director and Senior Lecturer at the Georgetown Center for the Constitution, and before that, a Vice President of the Cato Institute. Ilya is the author of Lawless, The Miseducation of America's Elites, which is coming out January. Placed orders now available for pre-order. And also Supreme Disorder, Judicial Nominations and the Politics of America's Highest Courts. He's also co-author of Religious Liberties for Corporations, and he's an editor of 11 volumes of the Cato Supreme Court Review. Ilya has testified many times before Congress and state legislatures and has filed more than 500 amicus briefs in the Supreme Court. He lectures regularly on behalf of the Federalist Society. He's a member of the Board of Fellows of the Jewish Policy Center, was an inaugural Washington Fellow at the National Review Institute, and has been an adjunct law professor at the Georgetown Washington University and University of Mississippi. Earlier in his career, Ilya was a special assistant and advisor to the multinational force in Iraq and practiced at Baton Boggs and Clearly Gottlieb. Before entering private practice, he clerked for Judge Grady Jolly of the U.S. Supreme Court of Appeals for the Fifth Circuit. He holds degrees from Princeton, the London School of Economics, and the University of Chicago Law School. Thank you for being here, Ilya. And finally, last but not least, Edmund LaCour, who is the Solicitor General of Alabama. Before joining Alabama Attorney General's office, LaCour was partner of the DC office of Kirkland & Ellis, where he represented numerous clients before the Supreme Court, courts of appeals, and trial courts. Before joining Kirkland, he practiced at Bancroft PLLC in Washington, D.C., and Baker Botts in Houston, Texas. Upon graduation from law school, Edmund clerked for the Honorable William H. Pryor Jr. of the U.S. Court of Appeals for the 11th Circuit, and he also earned his BA summa cum laude from Birmingham Southern College, his master's in philosophy from Trinity College in Dublin, and his JD from Yale Law School. As you can see, we have quite the lineup of experts. And last but not least, Monica Harris, our executive director, and I just wanted to give her an opportunity to say hello to everyone before we get started.
Hey all, thank you so much for joining us in the middle of the day and taking time out of your busy day. I hope you enjoy this discussion. It is incredibly timely. The court is hearing this case this week, and as you will see over the next hour, we think it's going to have extremely significant ramifications for the gender space and possibly beyond. So thank you again for being here, and hope you enjoy.
Thank you. So just to sort of kick us off here, I wanted to just give a little bit of a brief background on the case at hand, US v. Skrmetti. It is asked SCOTUS to hear this case. They are challenging a Tennessee law that bans medicalization of children, gender-affirming medical treatments of minors in the state of Tennessee. The plaintiffs in that case are a combination of originally, families of transgender youth in Tennessee who are challenging the law. And since it was originally filed, other plaintiffs have joined the case, including the Biden administration, the American Civil Liberties Union. And as you'll see, if we can kind of talk more about the various amicus briefs that have been filed, but this case has garnered a lot of attention from advocates on both sides. So the particular question that's being asked, that's presented to the court, in which the court will hear on Wednesday, is whether this Tennessee state law, which is Senate Bill 1, SB 1, whether it violates the Equal Protection Clause of the 14th Amendment. So depending on who you ask, the law is meant to protect children, or if you are on the plaintiff side, it is a law that is discriminating against individuals who identify as transgender in the type of medical care that they can access. So across the board, like I mentioned, there have been, I believe, someone correct me if I'm wrong, I think the latest count I did, there were somewhere around 60 briefs filed, and a pretty evenly split between the advocates on either side of the case. And we're very lucky to have 3 of them here with us today. So I would love to go ahead and start with you, Edmund, if we could. Your background on this and a case that you've been dealing with in your own state is particularly informative. You've been at this for a while now, so I would love it if you can give us a little bit of background about how Alabama came to be, running through its own litigation history, and then how, you came to file the brief that you did in this case.
Absolutely. Thank you so much for having me here today. So like Tennessee, Alabama determined that sex change procedures should not be made available to children. In 2022, Alabama enacted its law placing age limits on these procedures, puberty blockers, cross-sex hormones, and surgeries. And Tennessee's law sort of came along shortly thereafter, because later in 2022, a video from Vanderbilt University Med Center surfaced showing that kids as young as 13 were being given cross-sex hormones and others were receiving mastectomies. In the words of Vanderbilt doctors, they, quote, had very, very little data to guide the treatment and we're still figuring it out. Nevertheless, Vanderbilt's gender clinic director even presented a seminar titled Caring for the Transgender Patient with Little Evidence, but a Lot of Love. So this provoked a response from the Tennessee legislature in 2023. Like Alabama, they went ahead and banned these particular treatments as applied to children, so put age limits on them. In 2022, right after our law was enacted in Alabama, private plaintiffs challenged Alabama's law. They challenged Tennessee shortly after it was enacted the following year. As you noted, in both cases, the United States intervened as a plaintiff, which is not a common thing for the United States to do. It has to be signed off on by the Attorney General himself. In both cases, the United States and the private plaintiffs appealed to the authority of an organization called the World Professional Association for Transgender Health, or WPATH for short. WPATH is the group that authored the initial guidelines recommending sex change procedures for kids. And then other groups like the American Academy of Pediatricians and the American Medical Association have pointed to the WPATH guidelines to support their recommendations. In the view of the United States and the plaintiffs, WPATH's, quote, evidence-based guidelines, close quote, are proof that states restricting these treatments are out of step with the science Indeed, they've argued that because the science is so settled, only anti-trans animus could explain why states would not want children to receive what WPATH is recommending. So in Alabama's case, we had only a few weeks to assemble evidence before there was a short preliminary injunction hearing to determine whether the law could go into effect. The district court acknowledged that known risks of these treatments include loss of fertility and sexual function. But then the court stated in its opinion, nevertheless, WPATH recognizes transition medications as established medical treatments. The court went on to repeatedly reference WPATH's expertise before preliminarily enjoining Alabama's law. And then the next year, something similar happened to Tennessee. Now, this is where the cases diverge a little. Tennessee's case moved very quickly on appeal. The Sixth Circuit rejected the district court's approach from Tennessee and reversed the preliminary injunction, recognizing that just because the same drug might be used for two different purposes doesn't mean that these two different patients are receiving the same treatment. So for example, giving testosterone to a boy to bring his levels up to normal levels, it's just not the same treatment as giving testosterone to a girl to take her levels up to abnormal levels that would create fertility issues rather than remedy them. So the court said there was no sex discrimination, rational basis review applied therefore to the Tennessee law, which is very deferential to the states, and Tennessee's law easily satisfied that standard. Meanwhile, back in Alabama, after the judge put WPATH really at the center of the dispute through his earlier opinion, we decided to seek discovery from WPATH and from HHS, because the United States had come into the case as a full plaintiff, on the theory that if these WPATH guidelines might set the constitutional standard, we needed to know whether they were the product of dispassionate science or impassioned advocacy. And we believe that we ended up uncovering a shocking medical, political, and legal scandal that, in our view, has thoroughly discredited WPATH and also left the Biden DOJ with a black eye. So what we uncovered was that when WPATH
I'm just going to jump in to underline that point. Eddie's work, he and his team, I mean, this is remarkable stuff. His brief got coverage through all sorts of interesting media. Andrew Sullivan wrote about it. I mean, really neat stuff. If there's only one brief that you read in this entire litigation, it should be Eddie's.
Well, thank you for saying that. It was the product of multiple years of hard-fought discovery. WPATH did not just turn over their documents when asking for them. The United States claimed that we couldn't get access to any HHS documents. The district court disagreed with them in both instances, and so we did get tremendous access to documents that never before had seen the light of day. For example, they showed that the Standards of Care version 8, which I'll refer to as SOC 8, was authored by 119 authors, and every one of them was a member of WPATH, this advocacy group. One leader stated that it was important that each author, quote, be an advocate for transitioning treatments, close quote. That means that they be invested in a particular outcome rather than following the evidence wherever it might lead. The chairman of SOC 8 even testified in our case in a deposition that it was, in his view, ethically justifiable for these authors to advocate for language changes in the guidelines to strengthen their position in court. Another contributor wrote in an email, my hope with these standards of care is that they land in such a way as to have serious effect in the law and policy settings that have affected us so much recently, even if the wording isn't quite correct. So authors emphasize using the term medical necessity to make the guidelines a more effective, in their words, quote, tool for our attorneys to use in defending access to care. WPATH stuck with this medical necessity claim despite the lack of evidence to support it. They hired a team from Johns Hopkins to conduct systematic reviews of what evidence exists to support these treatments. That team from Johns Hopkins completed dozens of reports, which appear to have turned up little to no evidence. Indeed, in August of 2020, Johns Hopkins wrote to HHS about their research into multiple types of interventions, including surgeries and hormones. And she reported, the Hopkins research team lead reported to HHS, quote, we found little to no evidence about children and adolescents. And then HHS wrote back, quote, knowing that there is little/no evidence about children and adolescents is helpful. and keep that little no evidence line from the United States in mind as we get to the cert petition for the United States just a few years later. Johns Hopkins also complained to HHS that WPATH was restricting the review team's ability to publish its findings. WPATH had mandated the review team, quote, use the data for the benefit of advancing transgender health in a positive manner, close quote, which may explain why almost none of these reviews have ever seen the light of day. Worse still, some WPATH authors acting on the advice of, again, their words, social justice lawyers we spoke with, intentionally chose not to seek systematic reviews of the evidence before making treatment recommendations. And the reason they gave, again, in their own words, is, quote, evidence-based review reveals little or no evidence and puts us in an untenable position in terms of affecting policy or winning lawsuits. And then finally, there's Admiral Rachel Levine, the Assistant Secretary for Health at HHS. When the guidelines were essentially finalized, Levine was sent an embargo copy for review. That version included recommended age limits for these treatments: age 14 for cross-sex hormones, 15 for mastectomies, 16 for breast augmentation and facial surgery, 17 for vaginoplasty and hysterectomy, and 18 for phalloplasty. And even though these age limits were disturbingly low, Levine viewed any age limits as a problem. Levine and later the American Academy of Pediatricians pushed for age limits to be abolished completely from the guidelines. In the end, WPATH caved and removed the age limits with no explanation. Now, as they were litigating our case and the Tennessee case, the United States knew this. They are a party to Alabama's case where this discovery was produced. Of course, they're a party to the Tennessee case. Indeed, we think that may be the reason why the United States rushed Tennessee's case to the Supreme Court. The limited record in Tennessee's case would allow the United States to proceed on euphemisms about gender-affirming care. DOJ also used the filing of its cert petition in Tennessee's case as a ground for moving to try to pause all the discovery in Alabama's case and keep it under wraps, which, had it been successful, may have kept all this evidence under seal for years. Fortunately, we fought off that attempt and we gathered these documents and ultimately were able to tell this story in our amicus brief to the Supreme Court. So again, where this really reflects poorly on the current Department of Justice is that even though the federal government knew that there was little to no evidence supporting these treatments, DOJ told the Supreme Court in its cert petition that, quote, overwhelming evidence supports these treatments. And despite being involved in manipulating the political and legal document that really is SOC 8, the US hails the document as, quote, the accepted standard of care for treating gender dysphoria. Alabama, as I noted, has explained all of this in our amicus brief that we submitted to the court, and we hope that's going to prove helpful.
Thank you so much. You made the point that I think had been raised across social media about a week ago, the speculation that the ACLU specifically has driven the Skrmetti case up the chain to SCOTUS most quickly because perhaps above your own case, because there is such greater damning evidence in your case than in this one. You kind of alluded to that. Have you had conversations around that? Do you it seems like that's a very plausible possibility. Could you tell us more about how you feel about that take?
Yeah, I mean, in the words, I think Chase Strangio from the ACLU, who's going to be arguing on behalf of the private plaintiffs, appears to have said something to that effect, that there were going to be other cases with worse records and that the issue was going to reach the Supreme Court. So go ahead and rush the Tennessee case up there. And I think we've seen this in several of these challenges where plaintiffs have come in with a carefully curated record, carefully handpicked plaintiffs. They go to the court and they say, we need a preliminary ruling in the next, I think in Alabama, we had about 2 weeks before the hearing. In Tennessee, I think maybe 6 weeks between filing a lawsuit and the preliminary injunction issued by the judge there. And so these judges are trying to figure out all this medical jargon in a very short amount of time. And then you've got the experts coming in from WPATH, and you've got the AMA and the AAP and others saying, this is evidence-based. Trust us, not those yahoos from the legislature. And I think it's proven to be a compelling story until you get to dig in a little bit further. And I think that's the advantage that we've had in our case in Alabama, is we actually got to test some of those claims. Then you find out that these guidelines they're appealing to were expressly being crafted for purposes of sort of pulling the wool over the eyes of courts. And so we've made that abundantly clear with a whole slew of smoking guns that we found through this discovery.
Thank you. So really, I mean, your brief highlights the vast discrepancies in the stories being told about the efficacy of these medical treatments. Again, one side argues these are life-saving treatments. Another side argues that these are experimental at best, harmful, devastating at worst. Is it your contention that, how do you feel like the court will go forward with this? Is it going to be that they can't rule on the actual question that's been asked to them because there are such factual discrepancies, or what do you anticipate the justices will be looking for on Wednesday?
Ultimately, I think that the legal issue is quite simple. The whole argument teed up by the United States and the private plaintiffs rests on what we're calling the same treatments fallacy. Again, this idea that, well, if you're giving testosterone here to treat an endocrine disorder in a male who has abnormally low levels of testosterone, but you won't give testosterone to this female who has a mental health issue to raise her levels to dangerously high levels, then you're discriminating on the basis of sex. But that doesn't make any sense if you think about it for more than a second. Like, if you implant a fertilized egg in a female, it might be a fertility treatment. If you do that to a male, it's something altogether different. No one would think that that is the same treatment. Just like Lance Armstrong takes testosterone to win the Tour de France, no one thinks it's the same treatment as what a young woman with gender dysphoria might be seeking when she seeks testosterone. So once you understand that, their case completely falls apart. And so I think that will ultimately be the ruling from the court, that there just is not sex-based discrimination here. You're discriminating on the basis of totally different treatments, the purposes of the treatments, not based on sex. But it really is surprising that so many people have sort of advanced this argument when I think it's obviously fallacious nature. Again, if you think about it for just a few seconds, it really does seem to be totally bankrupt.
It is some wild stuff. Ilya, I would like to go to you next. If you could give us kind of the background on your history dealing with this issue, and you actually filed 2 briefs in the case. So are we like at 502 now, or did the 500 include these 2?
I stopped counting past 500. That's why it says over 500. Maybe if and when I hit 1,000, I'll have to update that. But luckily, in my bio, it says that I filed that many briefs, not written. I have good teams, but my name has been on that many. So it's not a party or an organization can't file 2 briefs, but as a lawyer, I wore 2 hats in this case. For the Manhattan Institute, which brief I'll get to in a moment, but also I'm counsel to Burke Law Group, which represented the Ethics and Religious Liberty Commission, the policy arm of the Southern Baptists. And we made, to segue off what Solicitor General LaCour was just saying, the basic legal point that there's no discrimination based on any constitutionally protected category here, because physically healthy kids, however they identify, whatever their orientation, don't get to undertake hormonal or surgical procedures to appear more masculine and feminine. And also the Bostock case, which I think 5 years ago now, ruled that anti-discrimination law, Title VII, has protections for sexual identity, sexual orientation, and gender identity. That statutory holding does not transfer to the constitutional context for assorted reasons. I think Justice Gorsuch, who wrote the Bostock opinion, is going to make that point. Look for that during argument this week and then in an eventual opinion. But now, as to kind of, that's the law. And as Eddie describes it, I think it is rather straightforward. There's no intent or effect of discriminating based on sex or or gender or orientation, identity, anything like this. But of course, there's a lot of battle of the experts and atmospherics, policy and political atmospherics going on. And so my larger brief that I filed together with my colleague Lior Sapir, who's an expert, he kind of does studies of studies on the gender medicine, it's what's lawyers sometimes call a Brandeis brief. That is, we don't make any legal arguments in our brief, but we present and we refute some contentions that so-called experts and researchers supporting the federal government's position here make. We point out that there's a well-established scientific evidence and growing international consensus against the use of so-called gender-affirming medications like puberty blockers and cross-sex hormones as first-line treatments. The most comprehensive assessment of the risks and benefits of pediatric gender medicine to date was conducted in the UK by Dr. Hilary Cass, and that was she filed a final report in April of 2024, finding that there was remarkably weak evidence for the safety and efficacy of such medications. And we're seeing further developments in the Netherlands and elsewhere, where the US is really the radical outlier because of that political dynamic with WPATH and the Biden administration that Eddie LaCure pointed out. And so our brief in part presents the affirmative case for why a state like Tennessee or Alabama might want to put in these restrictions, and responds to principally a group brief led by Dr. Meredith McNamara. We call it in our brief the McNamara Group, kind of an ode for Gen Xers and Boomers to the McLaughlin Group of yore. Kind of responding to the validity of their arguments and showing how they conflate the overall quality of evidence with the quality of individual studies. Anyway, you can really dive into those studies that we try to present to the court as it tries to make sense of the scientific evidence, even though, again, I don't think the court needs to really dive into that to make the rather straightforward legal points than it does. And I'll say one final thing before turning it back to you, Leanne, and listening to further commentary and questions. And that's that to the extent that there are political atmospherics, not just the law, not just the dueling policy experts and medical researchers, but to the extent that politics, that the judges are human, the justices are human. I think that atmosphere makes the court's majority more comfortable in voting to affirm the Sixth Circuit maintain these restrictions. That is, if there's one thing that the recent election showed, it's that the American people don't like cultural elites' radical posture on transgenderism, at least with respect to kids and women's sports. So to the extent that, for example, Chief Justice John Roberts doesn't feel comfortable taking bold positions on political controversies, he doesn't have to worry about that here, as he didn't with respect to, for example, racial preferences in college admissions. And I'll add one more thing, Leanne, and that's that, to be clear, some in the media try to characterize the support for these laws, which exactly half the states currently have, as some sort of conservative witch hunt, an attack, or bigotry on the LGBTQ community. I happen to be one of 3 lawyers in the country to have filed briefs supporting both Jim Obergefell in the gay marriage litigation and Jack Phillips, the baker in the Masterpiece Cake Shop litigation. So I care very much about civil rights, and this is a civil rights case about the rights of children, so they don't get swept up in these kinds of moral panics and cultural trends.
Thank you. You raised an interesting point about sort of the political atmosphere and what might be the motivation behind this case, or how the justices might feel in ruling on it. One of the, I guess, takes that I've seen raised online a bit is that this could somehow be an expansion of the Dobbs case, like a further intrusion on privacy rights by the Supreme Court in taking away the right to these treatments. What's your take on that particular argument, or it's sort of feels like a fear mongering type of play out of some of these activists? I just wondered how you feel about that.
Well, it's a different type of case. Dobbs was about a substantive right. This is about equal protection, and whether you're being bigoted against a minority that's protected categorically by the Constitution. The kind of stronger claim here is that it's a violation of parental rights. And indeed, through the pandemic and beyond, we've seen, especially those on the right, conservatives and libertarians, caring about what their kids are taught in schools and just asserting parental rights in a host of ways. Well, here it's the state that's coming in and saying, no, even if the parents agree that kids should have some sort of medical or surgical procedure here, the state is disallowing that. And that's because the governments do have a role in protecting children's developing healthy bodies, much as the same as in child abuse cases. You know, parental rights are not absolute. So here, in effect, the state is coming in to protect a children's rights, not because its views trump the parents' views on how to raise the kids, but because at a certain baseline, the state has a good reason to prohibit medical procedures that refashion healthy bodies based on a child's asserted or perceived or desired gender.
Thank you. That's really helpful. Next, I want to go to Mitra. Mitra actually is the architect and author of the brief that FAIR signed on to. So we're really excited to have her here today. And I would love to hear from you, Mitra. Your background really weaves in a lot of the central issues that are involved in this case, really when you get down to the roots of things here. And so I just wanted you to go ahead and give us a little bit of background from the legal work that you've done and how you got to be interested in filing a brief in this case.
Hey, thank you, Leanne.
Yeah.
So my background is in human rights, and that is the reason I got interested in this subject when I learned about what was happening there, with children and youth, and decided to investigate, this phenomena and try to understand what's going on. And I concluded that this is actually a violation of human rights, and it's a violation of numerous rights that we can't really get into here, but the violations occur because the treatments are so harmful and because there's no gatekeeping, no informed consent. It is sort of promoted to children, and parents don't always know. And in my mind, it's questionable that parents should even have the right to consent to such treatments for their children, because they are so harmful and irreversible with such long-term consequences for the child's life. So that is how I started getting involved. And because of my human rights background, my immediate focus was how can I make a legal case based on a violation of rights. And the obvious group, even though in my opinion it is a violation of all of the children's rights, but a particular group of these children is harmed very sort of based on identity, even though in my view it should not, I don't like to phrase it in identity terms, but basically children who are gender non-conforming, majority of them we know grow up to be gay or lesbian. And this group, or this characteristic, sexual orientation, is a protected characteristic, and it is a characteristic that is relevant to the treatment. It is a factor that should be considered in this treatment, and it is currently not being considered, and therefore it is a violation of the civil rights of gays and lesbians. And that is the angle I have taken in the lawsuits that I have filed, because internalized homophobia was disregarded as a factor in the process. Now, that becomes relevant to the brief that we filed, because we tried to bring it to the court's attention this phenomena of internalized homophobia. What is it and why should we care about it? And how does it interact with the rights arguments? And before I delve further into the civil rights issue of gays and lesbians in the context of gender medicine, I want to kind of backtrack or backstop into the government's arguments. The government essentially presents arguments that rely on the deconstruction of sex. That is the language and the philosophy that underlies or underpins the way the government argues. And so we try to reveal that, to explain that. So the deconstruction of sex, which essentially is the elevation of the subjective experience of gender over the objectively defined and verifiable biological sex, is harmful. If it is adopted in law, it will destabilize the law. And it is already been adopted in medicine, and we see its harmful consequences because it leads to poor treatment of children who have gender dysphoria. The government argues a stereotyping, but the stereotyping argument is rather weak because the law is just describing a condition, gender dysphoria. The law necessarily must describe this condition. So the law is not engaged in stereotyping, but the definition of gender dysphoria itself stereotypes roles, especially since the APA removed the guardrails in the definition. Is just gender nonconforming behavior in children. I mean, who's to say what toy children should play with? I mean, that in itself is a social construct. So when that becomes a symptom of a mental health condition that requires, in their view, medical intervention, it becomes problematic. Now, if we take deconstruction of sex into the Equal Protection Clause, we see that it violates the principles of the rule of law, not to be confused with rule by law, but rule of law, which means that the law needs to be stable, consistent, and clear, and not lead to ad hoc and chaotic consequences. And again, the conflation of sex and gender will necessarily mean that sex will be submerged into gender, and that will result in erosion of identity based on sex. So first of all, the government has no authority to erase an inherent identity. And secondly, women's sex-based rights cannot be erased. There is no justification for that, but that would essentially be the outcome if the Supreme Court were to adopt the deconstructed view of sex in its application of the Equal Protection Clause. So after that, we move into how the deconstruction of sex impacts medicine and how that is rooted in gender ideology adopted by the American Psychiatric Association and the removal of safeguards by WPATH. So WPATH is an organization that obviously plays a key role in, in ideological medicine. But I also blame the APA because the APA also removed important elements of the description of gender dysphoria or gender identity disorder. And what has been left in the DSM now are just the stereotypical characterization of children, plus the element of distress. But it is not sufficient to actually to lead to differential diagnosis, which is a necessity in protecting children, youth, adults, whoever might be suffering from gender dysphoria. And the American American Psychiatric Association, the APA, was also influenced by advocacy organizations. So it would be very interesting if it were possible to conduct any discovery on them to find out how and why, on what basis did they justify removing all the safeguards in the definition of gender dysphoria. I think I'll stop there because there's a lot more on the subject of the diagnosis and how it impacts gays and lesbians.
Yeah, no, that's really helpful. Thank you. I think one of the central issues that is really interesting to me, based on the work that we do at FAIR, is what you raised. And, obviously what's central to the case is whether the court will recognize transgender status as one that is protected at the same level as sex. As you said, Mitra, that would really essentially have wide sweeping impacts if the court were to do that. I'm interested to hear from all of you. What do you think the likelihood is that the court even addresses that specific question? And what do you anticipate would be the outcome if they do address that question? Anyone jump in, go for it.
So I don't think they'll ultimately have to confront the issue of whether transgender status merits heightened scrutiny, in part because I think Tennessee has a good argument that this law does not discriminate based on transgender status at all. And it's focusing on a certain type of treatment that has a certain risk and reward profile that they found to be too risky to merit giving to children, whether those children are trans or cis. And so there simply isn't sort of transgender-based discrimination for that reason. There's a case from the early 70s called Geduldig, the Supreme Court decided, where California had excluded pregnancy coverage from, I think it's like workers' comp statute, and there was an equal protection clause, sex-based discrimination claim brought, and saying that this discriminates against women because only women can become pregnant. And the court said, no, this is a coverage-based discrimination. And the fact that there are only women in one category, people who want pregnancy treatment, doesn't mean that you're necessarily discriminating against women, because you also have women in the other group of people who don't ever need the pregnancy coverage. The same thing would be true here. Even if you think that every child who has gender discomfort or gender dysphoria is a truly trans child, there are going to be children who are not trans, or who are trans, who never want these treatments or never seek these treatments. And so under Geduldig, you simply don't have trans discrimination. So there's no need to even confront the question of, if this were trans discrimination, would there be a category of people who merit heightened scrutiny like we apply to sex-based discrimination?
Thank you. Is that, Mitra, do you agree? Do you feel like it'll be sort of a clean sweep out of the gate where the court doesn't have to address that squarely?
Well, I think it depends how the court wants to address this. I mean, the Sixth Circuit also sidestepped the question by saying, well, it's really an age issue and it doesn't, address sex. But the question before the court is about the application of the Equal Protection Clause. So if the court wants to, truly answer that question, it would have to analyze, it would have to go through a full analysis of the Equal Protection Clause, which will necessarily have to address sex.
Thank you. Ilya, do you have any input on that particular question?
And I think my fellow panelists have covered the waterfront here. Yeah, I don't.
That's fair. One of the things that I think has been really interesting is that, just from a very kind of high level standpoint, when you look at the issue of whether a state can ban a particular medical treatment, here, all of us are very in the weeds on the evidence that there is for, or lack of evidence for medicalization of, children with gender dysphoria. But obviously states have a long history of regulating medical treatments, other activities of their citizens. I wondered if anyone can give kind of a few examples of how this is perfectly within the state's rights to do this, just to give our viewers an idea of, what are we really talking about here from a legal and a policy standpoint?
Well, Eddie might have some specific examples. He litigates and defends Alabama's positions all the time, obviously, but the practice of medicine itself is a state-regulated activity. There are national organizations that give guidelines and what have you, but there's a medical license in each state, and if you're certified in one state, you have to go through certain processes to be then authorized to practice medicine in a different state, and certain procedures are allowed and disallowed. I haven't looked at that aspect of this specifically, but it's not controversial that something is allowed in one state and not in another, or you have to be certified, you have to have more hours of practice, or different things like this, the way that licensure works. And where the overall point, though, the only thing that the court really needs to look at with respect to the medical evidence is, does the state have a good enough reason to make this restriction? And lawyers call this rational basis, or if it's a suspect category, then strict scrutiny or some higher level of scrutiny, as my fellow panelists just touched on, whatever that will be. But certainly, protecting kids from mutilation or unneeded or harmful medical procedures is self-evidently a good reason for having a medical regulation.
To chime in quickly, I mean, a few examples. Medical marijuana. States have sort of gone back and forth as to whether that is good medicine or not, how it should be allowed, to whom should receive those sorts of treatments. There's been debates about psychedelics more recently. One from just a few years ago in the COVID vaccine, it was FDA that needed to approve that, but no one had a constitutional right to sort of jump the line and get access to the vaccine before the FDA had approved it. And as Ilya was mentioning, I mean, states regulate medical professionals. The United States, the private plaintiffs here, we would argue, are trying to have WPATH regulate the states. But I think our brief shows, when you transfer power away from elected officials who can be held accountable by voters into these sort of opaque institutions like WPATH or the APA, people are still going to be exercising politics. It's just you're not going to know who's doing it or why, because it's all happening behind closed doors. And then the opportunity to correct course is going to be greatly diminished. If it turns out that Alabama and Tennessee have really gotten it wrong, and the evidence comes in and it turns out Europe has gotten it wrong too, when it comes to these treatments for kids a few years from now, you can correct course. Conversely, if the court constitutionalizes this area of medicine in favor of the private plaintiffs here, and the evidence continues to roll in that Alabama and Tennessee and 23 other states got it right, it's going to be very hard to sort of counteract that and sort of go back. So yeah, we think that these sorts of regulations are like common and have roots in that go back to even before the founding of the country.
Thank you. That's helpful. Monica.
Yeah, Eddie, it sounds like you believe the court might have an escape hatch and won't really need to address the issue of the legal distinction between sex and gender for constitutional for equal protection purposes, and so that they won't really be forced to resolve the case on the merits of transgender rights per se. I'm curious, what fact pattern do you think we would need to see in order to force the court to address the issue of transgender rights head on, so that, transgender individuals don't always have access to spaces held by biological men and women? As I'm sure some of our viewers are, and I certainly am curious as to what needs to happen in order to force states to put these protections in place. People keep hoping that the courts will address these very important issues, but they always seem to find a way to dodge them or sidestep them.
Yeah, so I think you have some fact patterns already available. You've got cases out there, cert petitions pending in the sports context, coming up out of West Virginia, Arizona, I think Idaho as well. Alabama's led some briefs in those spaces where you have biological males who want to compete on the girls' sports team. Those have been sort of kicking around in the lower courts for many years now. I hope the Supreme Court is ready to finally take one of those up and provide some clarity. In terms of the fact pattern that would really tee up sort of whether transgender status gets heightened scrutiny, I think thankfully that's not likely to come up. There aren't really any laws out there like you might have seen in Brown v. Board, where it said if you're Black, you don't get to go to this school. Or United States v. Virginia, where VMI said if you're female, you don't get to apply to VMI. There aren't really any laws out there I'm aware of that say if you are trans, you don't get to go to this school. Or instead,
I could see it coming up in the sports context. Somebody challenges their not being allowed to compete in, women's volleyball or whatever. I will say that there is a different kind of salience, or the parallel isn't exact in the sense that, well, to take Bostock, which I think is going to come up a fair bit in the argument on Wednesday, a man wearing a skirt was fired or not allowed to continue the job at the mortuary, if I remember the facts correctly. But if a woman had been wearing a skirt, that would have been okay. There's nothing like this in this case, in the sense that a boy is allowed to take testosterone to be more manly, but a girl is not allowed to take testosterone to be more manly. That's, there's no one-for-one substitution like that. In the sports context, I think they probably hard to avoid that sort of thing, and then they'll have to decide, biological sex or what identify as means, whether the discrimination is based on a legitimate factor like, differences in strength and safety and things like that.
Yeah, the strange thing about the sports cases and the bathroom cases, for that matter, is that unlike Brown v. Board, the plaintiffs want to maintain some sort of sex-based discrimination, or at least some sort of discrimination that's tangentially related to sex. Like, they're not coming in saying, we think there should be one basketball team at Duke and all the men and all the women try out for that team. They're saying, we want to have two different teams. We want a team called the girls soccer team, but we want you to redefine girl to be a little bit broader and include some biological males. And that sort of challenge, and we've articulated this in several amicus briefs too, that sort of challenge doesn't, or at least shouldn't, trigger heightened scrutiny. It's come up in this great case out of the Second Circuit called Janrock, where New York had race-based affirmative action for contractors, and they defined it to include, I think, African Americans and Hispanics. And their definition of Hispanic did not include people from Spain. And this guy, Rocco Luiere, applies. His mom is from Spain. He says, well, I'm Hispanic too. I want you to keep doing this race-based thing. I just want a piece of it. And you have to satisfy by strict scrutiny your decision not to include me as Hispanic. And Second Circuit said, no. Like, if you're trying to get rid of race-based government action altogether, then yes, strict scrutiny would apply. But if you want to just take advantage of it, well, that's an under-inclusiveness challenge. That only gets rational basis review. And we think if courts could get that that's really what's going on in the sports cases and the bathroom cases, those become really easy too. Because the plaintiffs always say, we're not trying to get rid of girls' sports. We just want in. And so we don't think heightened scrutiny even comes into play. But the Supreme Court has not ruled on that yet. Hopefully they'll take one of these cases, because West Virginia's got a great vehicle. They'd actually lost at the preliminary injunction stage, went through full discovery, and after a final trial, won in front of the same judge who initially said he thought their law was going to be unconstitutional, but then the Fourth Circuit reversed. And so it's a great set of facts. It's all really well developed. The case is called BPJ. That's up before the court now. They'll decide whether to take it or not. And then again, there are other cases coming up. So this will get decided. And I mean, it could be that you see things in the Skrmetti decision that will shine light on some of those cases too, but it doesn't necessarily the court doesn't necessarily need to address those sorts of things to rule for Tennessee in the Skrmetti case.
That's really helpful. And I actually raises a question for Mitra. For me, with a lot of sex-based discrimination issues at FAIR, we are working on protecting women's prisons as single-sex facilities. We've obviously dealt in the bathroom issue, the sports issue. And like you said, Edmund, it is okay, it is constitutional to discriminate on the basis of sex because there are differences between the sexes. And so my question for you, Mitra, and follow-up to that is, what is your take on why the US is so far behind? I mean, what do we need to do from a policy standpoint to make it clear to everyone that biological sex is real, there are males and females, and that there can't be different rules applied, you know, on the basis of those differences? I'm just curious to hear your thoughts on that, given your expertise in international law and what other countries have done.
Well, I think partly is that we have a decentralized system, so gathering of information and feeding it back to the people is a slower process, and we tend to be less questioning and more tolerant of new ideas. Like, who are you to judge? You know, like somebody feels whatever they feel, you know, like you can't criticize, you can't question, it's not socially accepted. So we are quick to accept new ideas, new identities out of kind of sense of, you know, like we are respecting people, as opposed to questioning and thinking critically, like, well, is this really correct? Is this backed up at something? What are the consequences of it? And the media also seems very lopsided in its coverage, right? And and again, lack of centralization. I think Congress is very slow to act. I don't know if it will ever act. And states, well, each state is going to go a different way, and then that leaves it to the court system, which is very slow.
Thank you. That's helpful. We're coming to the end of our discussion now, so I just wanted to give our panelists an opportunity if they have a final word to add here, or Monica. This has been such an amazing discussion. I know we had lots of viewership on X as well. We do post our webinars on our YouTube channel, probably about a day later. So for anyone wanting to review, please go ahead and check that out pretty soon. I just want to thank you all again for joining us today. As many of you know, FAIR is 100% donor funded. So if you liked this webinar, if you like the work that we're doing, please hop on our website. Tomorrow's Giving Tuesday. So if you're in the giving spirit, of course, we would love for you to consider making a gift to FAIR. Ilya, Mitra, and Edmund, thank you so much for joining us today and for all of your hard work on this very important issue. We appreciate it. Happy holidays
Thank you
to
for having
everyone.
us.
Thanks so much. And just a reminder to everyone, the argument is Wednesday morning starting at 10 a.m. The decision will probably be next June at the very end of the Supreme Court term.
Thank you. Thank you all. Have a wonderful rest of the day.
Thank you all for your time.